Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, reviewing a book that I've reviewed before for a few years ago now. One of the previous editions, I can't remember which one it was, but this one is a book which is very important for a lot of people. It's Shackleton on the law and practice of meetings. It's now come out in a 14th edition for 2017 and it's been written by a number of people. The general editors, however, are Madeline Cordes, or Cordes, I don't know how that's pronounced, so apologies in advance for any mispronunciation, and John Pugh-Smith. The book comes to us from Sweet and Maxwell and THOMSON REUTERS. Elizabeth and I have given a title for our book review, the following, relatively straightforward one, an absolute essential for how to conduct meetings. And that's basically what Shackleton is still all about. It's a book which I think is very easy to read, it's very easy to follow, and anybody involved in meetings, and that's an awful lot of people who are involved in one way or another with type of meetings that take place, will find this book helpful if there's something very serious that's going on. Let's have a look at it first of all. Here it is, hardback. There we go. Very much the house style of the Sweet and Maxwell. There's the spine, there's nothing on the back. Very much the house style. It's a heavy book, but it isn't that big. It's just over 400 pages long. There is a nice little, relatively short index with reference numbering. That's the style of the way in which Sweet and Maxwell wrote. I'll talk about that in a minute. Then you've got paragraph numbering at the sides and footnoting at the bottom. We go to the front of the book. There is the first page, and you can see that there are a large number of people who are involved in this book. So it hasn't been just a collaboration of two people. The total number, I'll mention their names: Madeline Cordes, or Cordes, John Pugh-Smith, Samir Abbas, James Burton, Geraldine Caulfield, Jonathan Darby, Paul Martin and Robert Waghorn. So those are people involved in it. There's the information about the book. It first appeared in 1934, so it's an old book now and it's been around a long time. Very useful preface. I borrowed a little bit of it for the book review from the editors. There's the detail about the contributors. So say a large number of people involved in it. Then you've got the structure, the table of contents, the legal right, the way it's developed over the years, the meeting. Then you've got the various chapter headings as we run through: public meetings, minutes, everything that you'd possibly think about. Members' voluntary winding up and so forth. Then it comes right to the end, 31 chapters in total. The last two chapters are defamatory statements, always interesting, that one, where there's privilege, and then charities at the bottom. Then you've got a table of cases. There are quite a few cases actually involved in this particular substantive law area, because as I've been involved in many meetings, you can see the table of cases there, and it's amazing how people can get really very uptight and then start litigating. So there can be problems. They're the statutory instruments following the statutes. And then after that we get to the book itself. Now let me just show you the structure. There's the chapter. You see how it's structured. Then you've got the heading, then you've got paragraph numbering, and you've got the footnotes. A lot of footnotes just going into the middle of the book, you can see. Now it covers really, I think, every single question that you're going to ask yourself about how a business should be run, what the legal requirements are, and what happens if things go wrong, because that's when the problems start. And there's always someone, I can tell you, it's certainly in the political meetings I've been involved in, and trade union meetings where you have standing orders and you have all sorts of additional things that come into it. People will quite often, if they want to set up in opposition against the people running some organisation, they will normally use the meeting as a method of trying to oust people. I'm not suggesting that you buy the book for that reason, but do bear in mind that quite often some people will say there has been something that hasn't gone right concerning a meeting, and therefore perhaps the decision making is either not what it should be, or in fact it could, in the very worst instance, be actually invalid, illegal, or whatever term you want to use. Okay, so what do we say then about the book? It's always, as I've indicated, I've reviewed this before, and I think it's a first-class statement on the law. It's always well worthwhile rereading, and obviously for this new 14th edition of Shackleton, which I say we've reviewed before, it never ceases, in my view, to disappoint with its clarity and friendliness when facing an awkward meeting and its members, because frankly you do get that on a regular basis with some types of activity which the meeting is covering. Now, the editors and their 5 additional contributors hope that it remains the authoritative source of information on the law and practice of meetings, and I think it is just that, because the new edition gives us a complete statement of the law with detailed practical guidance which we think will be of great benefit to all people involved at every level of meetings, from the beginner to the old hand. Now, the editors have included 2 new chapters covering what they call the increasing practice of holding virtual meetings. I think that's very important because of the 4th Industrial Revolution about to descend on us, and we're going to have a lot of changes. We've got artificial intelligence, we've got a lot of technological improvements, so virtual meetings are certainly something that's going to happen on a much bigger basis. Also, the other last chapter in the book has been added on charities, charitable meetings, and they've also reviewed, which I think is helpful, new decision procedures in insolvency proceedings under the new legislation. That's the Insolvency England and Wales Rules 2016. So this is the subordinate legislation. Now, the purpose of this work remains as an essential reference guide, and that's what it is. It gives you the sort of information which one finds necessary when preparing, conducting and closing a meeting. And the range of users of this manual, we think, will cover the everyday practice of legal professionals, company secretaries, administrators and clerks, directors, local authorities, and really any organisation that holds formal meetings. And that's really the beauty of the book, because it's actually it's also very readable. I think that's something I haven't put in the actual written review, but it's certainly very readable. Particularly impressed with the additional information about local authorities, because they're an important area in my view. Having said that, because I've been a councillor twice in 2 different local authorities, so I'm bound to say that. However, it's quite important when meetings are, there's the ever-present activity required at these meetings to get things done in the proper way within what we have and what we call our liberal democracy. That's particularly, as I say, important in local government. Now, the procedures and practices do tend to overlap, so we're delighted to see the commentary on the new case law authorities which have been included, which I think this gives us some thinking behind any form of judicial decision making should there be litigation. And please don't litigate if you can avoid it, but there are occasions when this does happen, and therefore we've got to have some indication from the bench as to their thinking. Now, what the writing team have done also is they've covered issues including bias, the delegated powers of officials, which is often quite substantial today, of course, and access to information. Now, this is at local government level, I hasten to add. The procedural changes which have risen from implementation of the Localism Act 2011 are also well covered, and I think that's important because again, I suspect that quite a lot of people are not as familiar with the Localism Act as they might be. It's not a long book at about 400 odd pages with 31 chapters and a detailed index which covers paragraph numbering rather than page numbering, and they use the Sweet-and-Maxwell legal taxonomy, which is explained at the back, but basically that's a link in to the type of substantive law areas which Sweet-and-Maxwell use as the norm. Now, that's very useful to know about for other publications because it's very much their house style. I found the footnotes particularly helpful as well, and they have been carefully limited to detail which the editors rightly think meets the balance between a detailed legal text and what is useful for lay people, and that's what you're getting here. As I've said, that's the 3rd time I've actually said that, but it's important because I think this is a very practical book. I'd like to conclude by saying that we remain extremely grateful to Sweet-and-Maxwell and Thomson Reuters for continuing to publish these titles at a time of difficulty for all, and also with big changes taking place, because it does make our lives a lot easier at a time when there are so many unrepresented parties around, who are involved in legal matters and need things explained to them. And of course we're all expected to have some form of legal expertise and knowledge today, even if some of us don't. So in fact this book I think is helpful because it's authoritative and it points you in the right direction. And the date of publication is the 1st of July 2017. This is the book again. It's a blue. I think the last one I reviewed was this nice blue background for the title, Shackleton on the Law and Practice of Meetings. And then there's the spine again there. They're just opening it up in the middle. Let's find something here. Now this is meetings of members of companies and examples of the sort of thing for companies. So as I said, although I talked about local government, this is also very relevant for corporate law. Meetings under Section 899 of the Companies Act 2006. So I'm looking at corporate governance there. Constituting a members' meeting. Notice all of the basic things that you would expect are there. And then right at the back you've got meetings of local authorities. Altogether I'm very pleased with this book. Delighted that they're still publishing it because I think it's the definitive word. And anybody involved in whatever type of meeting, if you're worried, especially if you're chairing it or you're heavily involved and you've got an obligation, I think it's useful to know about it. It's not expensive either, so do bear in mind. And thank you very much to everybody who's been involved in compiling this, because as I said before, and I'll say it again, you make our lives a lot easier. Thank you to all. Bye-bye.